This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviat. Tonight we're talking all about injuries. That's everything from car accidents to maybe you've been injured by taking a medication that was wrongly given to you. Pharmacy messed up and you took medicine you shouldn't have been taking. Maybe a family member's been hurt through nursing home negligence. Call in your questions, the 31 Law Call number, 256-536-0077. You can also now text to that same number. So if you've got a question you're a little shy about going on the air and asking it, text your question to us, 256-536-0077. We'll also talk about dealing with insurance companies, like filing a claim. What's the difference between filing a claim with your insurance company and actually bringing a lawsuit? Do you need to talk to a lawyer before you do either one of those? Call in. You can also email questions. You send it to lawcall@waytv.com. And when we get to a show that's on point, we have some of those. We've got some of your email questions tonight. We've also got Heath Brooks and Bobby Marsh from Timberlake League and Brooks here to answer questions.
Right. Yeah.
Y'all do these all day, every day, right?
We do. All day long, answer questions on the phone. Happy to do it.
Car accidents, medical malpractice, personal injury kind of things.
Anything like that, yep.
So while we get your calls locked in, we've got a little video for you. We like to pull something off YouTube every week, and we show you. You make the law call with this clip. So if you're driving along crowded highways, a lot going on, this is an icy road. Look at this coming from the other side.
Oh, no.
This driver's so lucky to have avoided that. You can draw your attention away from anything at any time. When you're looking at something like that, an 18-wheeler accident, what are you looking at as far as whether somebody is at fault? It's snowy and icy, things happen.
You know, you got to drive that is safe for the condition that's on the road at the time. You know, this one looks like something's going on the other side of the road. These people are coming on. Looks like maybe somebody probably hit some ice. You know, if they probably were traveling a little too quick for the ice, you got to go slow when you're, as slow as the conditions allow. So when I'm looking at this and I'm looking at tractor trailer that is coming across the road there, I'm wondering, one, was he traveling too fast for conditions? And then two, did he maintain control of his vehicle? He didn't do it. And I think in this kind of scenario, when you lose control of your vehicle like that on a highway, you're gonna be tagged for that.
Okay.
And that's especially important in any vehicle, but especially a large semi-truck with all the weight and the speeds at which they travel.
That's exactly
especially dangerous. Whole different animal.
So if you were injured with something like that, do you need to be careful what lawyer you take it to? Because, I mean, an 18-wheeler accident may be a little different from just something happening on, the highway.
You're right. It's a whole different ballgame. When you get involved in any kind of commercial wreck, but particularly with a long-haul truck driver, short-haul truck driver, there are federal regulations that a lawyer just has to know. And a lot of those regulations govern how truck drivers drive their trucks. Was the truck driver medically cleared? As a tractor trailer driver, you have to have to keep your CDLs, your commercial driver's license, you have to have a medical exam every year to ensure that you can safely operate your truck. The other thing is, were you over your hours? Were you supposed to be driving? In other words, if you're a tractor trailer driver, you can only drive a certain amount of time within a given 6 days, 7 days, or even sometimes 2 days. So you got to be incredibly vigilant about how to get that information. And a lot of lawyers, have never handled a tractor trailer case. They might not know where to look.
Yeah.
And the important thing is where do you look?
Okay.
That's right. And especially just to echo Heath a little bit, the evidence is a little bit different in those cases. For instance, a lot of these trucks, they have different cameras on board that you want to get and make sure that they're preserved. That's why it's crucial you get an attorney who not only knows what they're doing, but who gets involved early enough to preserve that evidence.
That's right.
Okay. We've got callers waiting. We've got Gerald on the line. Gerald from Huntsville. Gerald, I understand you had a knee replacement and something has gone wrong with it. How are you doing?
Hello.
Hi, Gerald. Thanks for calling. What's going on with your knee replacement?
Oh, yes, ma'am. I had a knee replacement. Now, this has been years ago.
Okay.
I had a knee replacement. I was supposed to be getting a partial replacement. Okay, and the doctors had already checked everything, and I was supposed to be getting a partial knee replacement, so then I wouldn't have that done, and I came from the hospital, and I was there for 4 days for joint count, but anyway, when I left the hospital, my knee was bigger than it was after the surgery.
Okay. Are you thinking they did a total knee replacement instead, or surprised you with something?
Well, they did the partial knee first.
Okay.
So I got home, and every 2 or 3 days, my knee would get bigger.
Okay.
So I would go back to the hospital. I went to the emergency room, and they pulled fluid off my knee. So they did this 3 times a week for 3 months, and then they said my body was rejecting the partial knee.
Okay.
Okay.
All right.
So they was going to have to do a full knee replacement.
Okay.
So when something like that happens, I mean, is that a medical malpractice case? Is that something to do with that?
You know, it can be. I mean, there are times when, as a doctor, you have to perform a surgery within the standard of care of the medical community. And what that basically means is that you've got to perform a surgery like every other doctor would perform that procedure or that surgery in the rest of the country. And if you deviate from that standard of care, then you can be responsible for the injuries that you cause. In that kind of situation, if you have, you know, a partial knee replacement and then your body rejects that actual device, which happens, and we call those, a fancy legal term is a known complication of that procedure, then you may have to do something else. What is a known complication?
A known complication is something that the doctors typically see when they perform this procedure. For instance, swelling could be a common situation depending on the specifics of the procedure they performed. I will say the important detail on this is that on a medical malpractice claim, you typically have 2 years. There are a few exceptions, but the rule generally is 2 years from the date of the alleged malpractice. So depending on when Gerald's procedure occurred, you know, it may unfortunately be too late, but...
You know, and there's just one other consideration here, is that whenever you have a device put into your leg, we see these a lot with hips. There were the striker hips at one point in time, but those devices can sometimes be recalled. And your time limits for those devices can be longer than 2 years, because you may not be able to find them. And those cases can be filed in other jurisdictions all over the country.
How would Gerald know if he got a defective knee?
There should be a serial number in the medical records. It's required for the serial number to be provided in the medical records. You can get your medical records and see what you have.
Good luck with it, Gerald. We've got Ann on the line with a question from Athens. Ann, I understand that you have a friend in a nursing home that got injured. How did they get injured?
Well, they slammed the work cart against my back.
Oh, it's you. It's not just a friend got injured. It was you. Okay. Who slammed something again? And don't name names, of course, or the nursing homes, but a worker in the nursing home slammed a cart into your back?
Yes, she slammed me first. And then when I went to get a drink of water, she slammed this work cart into my back, and I can't hardly walk.
Slapped you? Did I understand you right? Slapped you first? Okay, that can't be an accident.
No, and that's an intentional conduct. Okay. But in those kinds of situations, sometimes the nursing home can be responsible for the conduct of their employees.
Okay.
Particularly if you're not vetting your employees and ensuring that you have employees that are in place that are not going to react violently. But if you're hitting someone and you're striking someone, that goes beyond what we do in the civil world, and that goes into criminal conduct.
Okay.
You can't, that's assault. You can't strike someone, you can't hit someone intentionally, or else you could be criminally responsible for that.
Who does she go see about that? Who do you go to, a lawyer, or go to the DA's office, or go to the police?
All of the above.
Okay.
You know, first things first is contact the police. Probably there's a social worker that is involved, and also contact the Alabama Department of Public Health.
Okay. All right. We got this text in. Said we can now get your text messages to the same number that you see on your screen. I was misdiagnosed with my illness and given the wrong treatment. What should I do to ensure that never happens again? I bet you guys are very cautious with your family members, telling them, here's how you talk to your doctor. Here, you take notes, you do whatever. How do you prevent something like that from happening?
What do you think, buddy?
You know, the main thing that we see a lot are people, it's very, very important that you advocate for yourself when you go to your doctor's office. You know, if you have common drug allergies or things that you're aware of, it could be helpful to have a drug allergy card that you present to them when you first meet with a doctor. Anything that you can do to speak up for yourself and let them know, hey, look, I've reacted to this, negatively in the past. I don't want to, be prescribed that or be given that again. Doctors have different prescriptions they can provide you in that situation, so it's just important to speak up.
Good. They're telling us to take a break. We're going to take a break, be right back answering more of your questions all about injuries tonight. Stay with us.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back tonight. We're talking all about injuries. We've got with us Heath Brooks and Bobby Marsh, both from Timberlake League and Brooks. They do personal injury cases all the time. They also advocate for good fundraisers like this one for raising for money for the Madison County Volunteer Lawyers Program. What is this?
It's a great organization, the Madison County Volunteer Lawyers Organization, and what they do is they provide free legal services to folks who don't have enough resources to provide to pay a lawyer for those services. And this is a big fundraiser we have every year. It's on September the 2nd. There's a 5K, there's a 10K, and there's a 1-mile fun run for kids. Last year they had a couch run. You could donate, you could sit on your couch.
Just sit on your couch.
That's right.
Hope they're doing that one again.
You still get the T-shirt, even if you do the couch?
Yeah,
Excellent.
you get the T-shirt.
That's the fun part. So good. Enjoy September the 2nd.
Great organization.
We were just talking with Ann before, and she was talking about abuse and say that she had been abused in a nursing home. You wanted to talk a little bit more about that?
Yeah, you know, and we've seen this from time to time in our practice. We do a lot of nursing home work, but we've seen it from time to time in our practice where we'll get a call from a family member and there'll be some sort of marks on their loved ones, or, you know, so there'll be some indication that their loved one has been abused. And, you know, when you're in a situation and when you're in a nursing facility and you're relying upon people for your food, your clothing, your shelter, to help you with baths, to help you get from place to place, to communicate with you, then sometimes those same people who are supposed to be there to help you and you are relying upon also take advantage of you. And that's a form of abuse, and that's something we don't tolerate in any nursing facility, or really we shouldn't tolerate in our society. So this is a very serious situation when you've been assaulted in a nursing home, and it's something that both the district attorney, the police department need to know about. You call the police department. Tell your loved ones when they come to you, and maybe you're scared, maybe you don't want to speak, maybe this person who's abusing you has told you if you tell someone they'll continue to hurt you. Tell your loved ones. Tell somebody. That takes a lot of bravery to do that, but we will not tolerate that in our facilities.
Yeah. We got this text message in from Brenda and Leland. They were concerned about signing releases for children. They said they take their grandchildren to amusement parks, trampoline parks, and things like that. And oftentimes they want you to sign a waiver for your kids, your grandkids. Is that effective? If the child gets hurt, are the grandparents going to get sued, or what happens?
What you think, Bobby?
Well, so an important rule to keep in mind is that under Alabama law, a minor cannot sign a contract. So a lot of times there are different, I don't even want to use the word loopholes, but ways these contracts are not enforceable. These waivers are not. It's a common situation that we see a lot. Just think about how many waivers you sign in your daily life. Sports teams, trampoline parks, amusement parks, places you go. So there are different ways that these waivers are unenforceable. And like I said, kid can't sign a contract. So that's one way.
You know,
some others.
They're pretty harsh, these waivers. We see them a lot, and a lot of times they'll, you know, if you get hurt, say you walk into one of these water parks yourself and you're an adult and you sign one of these contracts and you slip in some water and you fall and you break your neck. You have signed a waiver. And you as an adult have agreed to accept the services or wherever you're going, whether it's some trampoline park, whether it's a baseball field, or whatever the case may be, you can do that. And you get hurt, and even if the other side's negligent, you have waived your right to bring any kind of action against them. The difference is that when a parent signs a waiver for a child, because a child can't make that determination, and a parent can't make that determination for their child. So if you do sign a waiver and your child does get hurt because of the negligence of some, you know, other company, then it's something you probably need to contact a lawyer about.
But I bet that park, that water park, will tell you, oh, it's effective. You can't. It's over and done. And if you believe that, you've given up your right to do something about it. We got this text message in. Jan from Grant had written in, my mother has dementia. She fell after a stay in the hospital, and she was sent to a rehab facility. She was there 2 days, and her hearing aids came up missing. Well, we reported it. It turned out later it was found in the washing machine. You know how expensive these are.
Yeah.
The folks at the place are saying it must have been just rolled up in the sheets or something. Is there anything that they can do about that? So that kind of property is very expensive.
Oh, yeah. Hearing aids, 7, 10. You
Yeah.
can pay as much as you want for hearing aids. Thousands and thousands of dollars for hearing aids. Yeah, and it is your loved one's property. So your loved one, they have dementia, maybe there's somebody who has a power of attorney. It is possible for you to bring an action in district court, which is a court in the state of Alabama where you go to put your grievance in front of a judge, and your damages could be limited to $20,000, and you have a potential to bring a claim against the nursing home in case they won't give you the money for the hearing aids. The first thing, though, before you have to take that kind of drastic step, is contact the nursing home administrator. See if you can have a reasonable conversation with those people, that person, about whether or not they can pay you back for the hearing aids. And if they can't, then you may have to take that step. I don't know I don't know that after you put all the effort and all the time and all the expense into handling that case, whether it'll be worth your while, but you do have that option.
Okay. We got this email from Doug. Doug had written in, several months back, I was hit in the driver's side door by a woman that wasn't paying attention and ran through a red light. I've still got pain and discomfort, but after 2 MRIs, nothing shows up. Her insurance company has asked to see my medical records. Should I allow that? I'd like to settle and move on. What do you think?
So the answer is really, it depends. You may end up needing to reveal some of your medical information, especially if you're making a claim for medical bills and damages of that sort. But you don't want to just give the insurance company everything you have. You want to be selective with the information that you provide them. You're not trying to hide anything, but they don't need to see all of your medical history or all of your medical records that may or may not be related to your accident. So our advice would be to contact an attorney just to make sure, hey, vet everything out. It's always good to ask before you submit information to the insurance company, and that's what we're here for. We're glad to talk with you about that.
The one thing about that is that when you send your medical records to an insurance company, they're going to have you sign what's called a HIPAA authorization. Okay. And a HIPAA authorization just basically says, okay, insurance company, you have a right to look at my records, or you have a right to get my records. A lot of times when you sign that HIPAA authorization that's given to you by the insurance company, you agree to let the insurance company have all your past medical records. You agree to sometimes even let the insurance companies get your school records and your work records. So if you just do not contact a lawyer, you want to take care of it on your own, and an insurance company wants you to sign a HIPAA authorization, make sure that's all you're signing. Make sure you're not signing something that will allow this insurance company just to gather information to try to take away any kind of rights you have to compensation that you may be entitled to. Because I can tell you, if they can find it in your records or your work records, they're going to.
Okay. Talking about that, should you talk to the insurance company, or should you be very careful so not even related to this one? Let's talk about, you've had a car accident.
Right.
And you need to talk to your insurance company or the adjuster. Is that okay to talk to them?
I always say talk to a lawyer first.
Okay.
If you have a car wreck and you're injured, or even if you have a car wreck and you just have some questions about what's going on, I always say just talk to a lawyer. Most of the people who do my kind of work will talk to you and won't charge you a nickel, give you some advice about how you can move forward, particularly if this is just something you've never done before. And so it's always good to talk to somebody who's been through that and can give you at least some guidance. It may not be a situation where you need a lawyer to represent you, but it can't hurt to ask.
What are they trying to get you to say then? What are they looking for?
They were trying to get you to say that you were traveling 56 in a 55-mile-an-hour zone, and maybe you contributed to your negligence, because in the state of Alabama, we have contributory negligence.
And we're the only state in the union with a law that's this strict. Most states, they have what's known as comparative negligence. But here, with contributory, if you contribute whatsoever, any percentage, even 1% at fault, if the jury finds you to be 1% at fault, you recover zero. You are legally barred from recovering anything. And that's why it is so important to not only understand what you're signing, but what you're saying as well, and what those words can get you into with the insurance company.
Interesting. Be careful. Okay. We got this email question from Todd. Todd says, I was wondering what the statute of limitations is for wrongful death. I was wondering because my mother-in-law died, and we just got her records after fighting with the insurance company, and it shows that they gave her way too much of a drug. It was actually Ativan, too close together, and she died 2 hours later. Okay, but he's worried about, has it been too long to do something about it?
Well, first off, you got 2 years.
Okay.
After the death of your mother, you got 2 years to file a lawsuit.
Okay.
If you don't file within 2 years, then you forever lost the opportunity to do so. In Tennessee, it's a year where I also practice law. But the important thing is that not only do you have a time limit, but a lot of times if you don't move forward with a situation where you think there was some wrongdoing, then evidence is like water. It evaporates. And so in this kind of scenario, you'd want to gather your medical records like you did, and then you want to talk to some of the people that actually were involved in the care of your mother. A lot of times that's going to take talking to an experienced lawyer who handles these types of cases, who can get the information that they need and really get to the bottom of how your mother was ultimately killed by these people.
Okay. We got this email question from Alicia. Alicia says, during football practice, my son's tooth was broken. While on the sidelines, one of the other players grabbed my son's face mask and yanked it, breaking my son's tooth in the process. The player admits to it. These actions were done without any provocation from my son. The parents refused to pay for my son's dental bills. Are the parents liable for this act? And what responsibility does the school have?
What do you think, Bobby?
Well, any claim involving a school is a little bit tricky, you know, because under Alabama law, schools are entitled to immunity. Now, what that, so essentially it's very difficult to hold a school liable for a situation, especially something like this. That's why it's important to talk to a lawyer to see, what do I need to do in order to hold the school liable for what happened to my son? You may have a claim against the football coach, for example, maybe a negligent supervision claim, something along those lines. You could also have a claim against the parents if they were to know, or if they knew that their child could have acted this way, maybe something there.
Yeah.
But
and we've had situations where there have been sporting events or something occurred on school grounds from another student. And sometimes if in a football game or in any kind of athletic dangerous activity, you take the risk that you could get hurt. That's part of the game. However, in a situation where it's unprovoked and another student injures you, the homeowner's insurance of the parents may cover that injury. And we've had been successful there.
Homeowner's insurance. Okay.
That's right.
We're going to take a break. Be right back answering more of your questions. Stay with us. If you haven't gotten your questions answered tonight, here's how to get in touch with Heath Brooks and Bobby Marsh with Timberlake League and Brooks. They are personal injury attorneys. The number 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon handles all things family law related, as child custody, divorces, and the like. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
It is so hot out this week, landlords have got some responsibility.
That's right. We get calls this time when there's 100-degree heat out. Hey, look, my air conditioner's out. I can't get my landlord on the phone. What do I do? And one of the things that you can do, is you need to call the Madison County Health Department quickly. But the other thing is a landlord in the state of Alabama has a responsibility to maintain the environment, your condo, your house, in a habitable environment. And what that means is they got to keep it cool. So call them if you need to.